Yeah, I mean, now I understand that Yasmin is a tenant. She can't be evicted without her landlord following the correct procedure. And you did mention that different tenants have a right to stay in their home. So could you explain this more?
Building on what you already know about the steps to evict a tenant and what a tenancy is, we then look at additional protection if you are occupying the property as your only or principal home. And the rights differ depending on whether you rent from the council or a housing association or you rent from a private landlord. Okay, so the next slide is just recapping what I've just said. Okay, so you can lose your protection as a residential tenant if you are not actually living there or you've illegally sublet your property, if you're renting out a room or you're renting out the property to someone else. In that case, if you have done those things, then you just have the basic rights as a contractual tenant and none of the additional protection that would apply if you're a residential occupier. The key difference between non-occupation and subletting. If you haven't been living there as your home and your landlord issues a notice to quit, treating you as a basic contractual tenant, but then you return to the home to live there as your only or principal home, then the landlord cannot rely on that notice to quit. They might still try evicting you for any unpaid rent or any problems at the property in the meantime, but you would still be able to enjoy your rights as a residential tenant. However, if you sublet your home, firstly, it could be a criminal offence if you've done it as a housing association or council tenant. But secondly, once that's been done, you lose your rights to the property. So all you have is a contractual tenancy from that point on. Even if you do return to live there as your home, once you've parted with possession of some or all of the property, then your rights as a residential tenant have ended. So the landlord would issue a notice to quit again to bring your contractual tenancy to an end. They'd still have to apply to court to get a possession order, but you'd have no further rights at the property.
So you said you need to live there as your only or principal home to have extra protection.
That's right.
What if I'm away for a while, but I still want to live there, like at uni, for example?
Okay, well, as long as it is your only or your principal home, even if you're absent from the property, then you've still got a tenancy there. Now, if your absence is short term and you're still coming back to the property regularly, then I would expect the landlord to carry on treating you as a tenant. So, for example, if you're a student and you return to the home during the holiday times to live there, you're still paying rent there, there's still evidence that you're intending it to be your only or principal home. If your absence is unavoidable, even if you've been away for some time, then it's still your only or principal home. So let's say I'm in hospital and I've been in hospital for the last couple of years, but I still intend to return to this home when I'm fit to come out. It's still my home. Now, paying the rent in the meantime while I'm away might be a problem, but in that case, I'm still a residential tenant. So a court may still have discretion to stop me being evicted. If I'm in prison, I'm involuntarily away from the home. So I still regard this as my only or principal home. But again, I've got practical problems in how I pay the rent. But if I choose to be away from the home, then at some point there's going to be a question whether where I'm staying is more of my home than where I've got this tenancy. If I'm in a relationship with someone else, I go to stay with them most of the time, I just come back to my tenancy periodically, then the landlord might decide at some point that where I've been staying with my partner is my principal home, not here. Even though this is still a home, it's not my principal home in that case.
What information do I need to work out what sort of tenancy I'm dealing with?
Okay, a good question. And here we've got most of what you need written down. Now, some of this information you've already got from Yasmin, or you can find out in your interview with her. Now, what's on the left-hand side is the information to work out if you're dealing with a tenancy. And then the information on the right-hand side will help you work out what type of tenancy it is that you're dealing with. So we've talked about the 4 elements that make up a tenancy. Those are the questions that you're wanting to find out on the left-hand side. And then on the right-hand side, we're looking at when you started living there and when any agreement to live there might have started, in case those are different. Who is the landlord? So we would typically break it down by looking at if you're dealing with a council landlord, dealing with a housing association, or you're dealing with a private landlord. Again, are you living there as you're on your principal home? Do you have a resident landlord? Are there any reasons why you shouldn't have statutory protection? And again, the short tenancy checker will prompt you with the further questions to check further situations where you might be excluded from statutory protection. But common ones include what we've talked about. Living in tied accommodation, you might be a caretaker in a school and live on site in order to look after the school. Or you might be a pub landlord,
right,
or working for a pub.
Yeah, I was wondering what that was. I hadn't come across that.
Okay, so in tied accommodation, if you lose your job, you lose your housing too.
I know that in Yasmin's case, she rents from the council and she's been there for 3 years. But what are the different types of tenancies within that I might come across?
If she's a council tenant and she's got long-term protection, then she'd have a secure tenancy. So that the council could not just give notice to make her leave, they could only get her out of a property if she's broken a condition of the tenancy or a ground for possession that's set out in the Housing Act 1985 that governs secure tenancies. If she was only there for a short time as a council tenant, she may just have an introductory tenancy, which is like a probationary tenancy for new tenants. For the first 12 months, it's easier to evict an introductory tenant than a secure tenant. But if they've passed the 12-month period, or if it's extended, the extension period for that, as long as they pass it without the landlord applying to court to evict them, then they automatically get stronger rights as a secure tenant. But you may also deal with some council occupants who are living there as temporary accommodation, particularly for households that are being dealt with as homeless people, where the council's either assessing their needs or is waiting to be able to offer them longer term accommodation elsewhere. Now, if they don't have exclusive possession, especially if they're living in emergency housing, they might just have a license to live there, like we talked about before. Or this is one of those circumstances where they could be excluded from the standard protection from eviction. If they're in self-contained accommodation, they'll probably just have a basic contractual tenancy there. But the most common ones are the secure or the introductory tenancy. If you're a housing association tenant with long-term protection, then you'll probably have an assured tenancy, which is like a secure tenancy, but with different grounds for possession. So a landlord would still need to apply for a court order to evict you, only on specified grounds for possession, but you have to look at different grounds for possession than with secure tenants. Now, housing associations don't have introductory tenancies, but sometimes as an alternative for probationary tenancies or as fixed-term tenancies, sometimes to house homeless households, they do use assured short-hold tenancies, which are the same basically as assured tenants, but a short-hold means that there's a fixed period of the contract. A minimum of 6 months, could be longer, could be several years. But at the end of that fixed term contract, the housing association has got a guaranteed right to repossess the property just by giving notice. During that fixed term contract, if you break the agreement or you break one of the grounds for possession, they can evict you just like with the grounds for possession with assured tenants. But they've got that additional way to evict you if you're an assured short tenant just by giving notice, with no need to give reasons for it. And then if you're a private tenant, unfortunately, it's very rare to have long-term protection. You do still get assured tenancies in the private sector, but most landlords would choose to use assured shortholds, which is now the standard. So it's assumed, even if you've got nothing in writing, that your landlord intends giving you a fixed term contract for 6 months. You've got a right to get a statement of the key terms and conditions of your contract from the landlord, but the assumption is in law is you've just got protection for 6 months, and the landlord could give 2 months' notice to end that tenancy, then get a possession order, then get the bailiffs to evict. Just like with housing association short-hold tenancies. Lastly, we mentioned about people who may be lodging with resident landlords. In that case, they're not going to be tenants. They're just going to have a license to occupy the property. So the landlord could give notice and then evict them without a need for a court order or the bailiffs. And that's a very, very brief summary of this. It's not every tenancy you might possibly encounter, but these are the most common situations. And on the next slides, we've highlighted key information about each tenancy. We've looked at the steps a landlord needs to take to evict. And we've looked at how landlords could evict someone for rent arrears in those different types of tenancy. So I'll let you look at those at your leisure, and you can pause and continue when you're ready to. So starting with the council tenants and the secure tenancy.
Yeah, because this is what Yasmin has. She's got a secure tenancy, hasn't she?
Yeah, that's right. It also applies to some housing association tenants, but only if their tenancy started before the 15th of January 1989. In all other cases, a similar housing association tenant would be an assured tenant. Okay. There's only one way to evict a tenant for rent arrears under the Housing Act 1985. There's one ground for possession, for breach of tenancy, or for unpaid rent. In that case, the court has got an absolute discretion. You could owe £20,000 worth of debt, and the court can still refuse to evict you. Or you could owe £1 of debt and be evicted because the court believes your behaviour, for other reasons, has been completely atrocious. So that is how wide the court's discretion can be. It's very unlikely you're going to be evicted, at least to start with, if you owe a low level of debt. And it's still possible to stop evictions with high levels of debt, but a court would need to be satisfied that it's fairly unusual circumstances that would justify keeping someone in there, the bigger the debt gets.
What if Yasmin had only recently moved into her home and she'd stopped paying the rent?
In that case, the council would probably have given her an introductory tenancy, not a secure one. If a council is going to use an introductory tenancy for one tenant, it has to apply for all tenants in that area. But for the first 12 months, as a council tenant, unless an exception applies, they're all introductory tenants. So if this was within the first 12 months, they don't need to give reasons. They can just give notice to explaining why they're giving notice and inviting Yasmin to exercise her rights to ask them to carry out a review of that decision. But if they review the decision, or she never asked them to review it, then they're free to go ahead, get a possession order, and there won't be anything the court can do to stop that eviction. Basics on rent arrears and secure tenants. Just a summary for eviction and introductory tenants. Okay, now I say that the court has got no discretion. If the council has acted unreasonably in evicting an introductory tenant, it may be possible for a housing solicitor to prevent someone losing their home on public law grounds. Generally, if a council is acting unreasonably, a tenant could use their rights to make a complaint against that council, and then if they're not satisfied with the action council takes in response to that complaint, they could ultimately complain to the local government ombudsman. And that might be one solution if the council is trying to evict someone for a minor problem, or where the tenant absolutely disagrees with what the council is alleging, but the council is still insisted on applying to court for an order. Alternatively, it may be possible in limited situations for a solicitor to use public law defences if the council has acted unreasonably. But that's a lot tougher. There's no discretion with the judge. Essentially, a solicitor would be having to apply for an injunction to prevent the council acting on that notice. The best thing a tenant can do, If they're an introductory tenant, it's use their right to ask the council to review their decision, explain why they don't accept the council's decision, or if they do accept it, if they're in rent arrears, to explain what they've tried to do about it and to ask for a second chance. If they miss that review process, then there won't be anything that a county court judge should do to stop the eviction. All the judge could do is delay it for possibly 6 weeks.
Okay, so putting Yasmin's case to one side for the moment, sometimes we advise people who have been made homeless and they're living in temporary accommodation. So what are their rights?
Unfortunately, very little. So as we talked earlier, if you're living in a hostel, you've probably just got a license to occupy, which can be ended by the landlord giving notice. When you moved in, they may have given notice that this is either a night-to-night license that they can end at any time, or that it's the license for a fixed period that they may decide to extend, but basically the license is coming to an end at a certain point. Or they may have said this is from week to week until your case has been dealt with, or until further notice. So if you just have that license and you don't have exclusive possession, then your permission to be there ends when the license says it ends, or when your landlord gives notice, and they're not going to need a court order to evict you after that. If you do have exclusive possession, then it's the same rules as with your basic protection under the Protection from Eviction Act. So the landlord would have to issue a notice, get a court order, and then get the bailiffs to evict you. But in that case, there wouldn't be any discretion on the court to stop your eviction. It's just a question of how much time you've got before you have to move out.
Okay, so we know Yasmin's a council tenant and she's got long-term tenancy, but we also advise housing association tenants. So let's say Yasmin had a long tenancy, but with a housing association, what rights would she have?
Okay, so probably if she's got long-term protection, she'll have an assured tenancy. And that's similar to a secure tenancy with a council, but slightly different. So the rules around rent protection are different, the rules around who can inherit the tenancy are different, and grounds for possession are different. There's a completely different set of grounds for possession for assured tenants compared to secure tenants that we'll look at. The housing association still could not evict someone with possession, but check because they are likely to be different ones. Okay, so to evict a tenant for rent arrears as an assured tenant, there are 3 grounds for possession that apply to assured tenancies. The first 2 are discretionary, and they might as well be just the same as ground 1 for possession against a secure tenant. The court's got discretion not to make a possession order under grounds 10 and 11. Ground 10 applies if the tenant owes some rent arrears, whether it's £1 or whether it's £5,000 or more. Ground 11 applies if the tenant is persistently late in paying the rent, even if they don't owe any rent arrears at the date of a court hearing. But it's up to a judge to be satisfied it's reasonable to evict someone in the circumstances. So if the only reason for your rent being late is because it's paid in arrears by benefits, that's not going to be a sufficient justification for the landlord to get a possession order. Ground 8 can be a problem because it's compulsory. If a tenant owes 8 weeks or 2 months worth of arrears at the date of the notice, the date of any subsequent court hearing, and the landlord chooses to rely on ground 8, then the court must make a possession order. There's no defense to it, and the only thing a judge could do is give you more time to pay. That's the general rule anyway.
Okay, so what can I do if I'm advising a tenant and their landlord has issued a notice that is relying on ground 8?
Well, first off, I think it's always worth negotiating with landlords, whoever they are, and especially social landlords like housing associations would usually want to find out what the reason is for any problem before taking action. They may be willing to negotiate, they may be willing to give time before applying for a possession order, or if the case is already at court, they may be willing to agree to postpone a court hearing to give you more time to resolve any problems like with benefits or debt. So firstly, it's always worth negotiating. If the landlord won't negotiate, if they're acting unreasonably and they're a housing association, then they're a public body. You've got a right to complain to them. And if you're not satisfied with the outcome of your complaint, you could then refer your complaint to the housing ombudsman. The housing ombudsman may decide that they're acting unreasonably and request that the housing association takes a step back and reconsiders your situation. And broadly, councils and housing associations should take into account the tenant's circumstances and the reasons for any problem. They should offer support to help a tenant to deal with it. It's part of the pre-action requirements for court proceedings, but those pre-action requirements only apply to councils and housing associations. They don't apply to private landlords in the same situation. Okay, so now let's look at assured short-hold tenants. So remember, it's the fixed term contract for a minimum of 6 months. It's broadly the same as a standard assured tenancy, but with that extra right of the landlord that they can just give notice to bring the contract to an end at the end of the fixed term contract. If the landlord hasn't given notice to end it, then you carry on with your rights as a tenant after the end of the fixed term. But now you're a statutory periodic tenant, but still within a short tenancy. And that will carry on until the landlord terminates it by giving notice, or you're given a fresh contract by the landlord. So to evict an assured short-hold tenant, let's say I owe rent arrears. During the fixed term, the landlord could give me a notice based on grounds for possession, just like for assured tenants. So depending on how much is owed, it might be discretionary grounds, it might be compulsory grounds. Or the landlord could figure that the easiest way to evict me is just to allow the fixed term contract to come to an end, especially if it's only for a 6-month contract, and just give me 2 months notice before it ends. And there won't be any discretion with the court. The court would have to give the landlord a possession order. I'm out of the property in 6 months' time. So depending on how much time there is to run, a landlord might choose to use grounds for possession, or they might just choose to terminate the contract at the end of it. I'll still be liable for any rent arrears owed up until then.
So really, you're saying if I'm advising a tenant who's got an assured short-hold tenancy and they've been given the 2 months notice, that there's nothing I can do to stop the eviction?
Not quite, because although the court's got no discretion, if a landlord hasn't fulfilled their legal responsibilities as a landlord, then the landlord may be barred from using Section 21 notices, which is that 2-month notice that brings the contract to an end at the end of the fixed term. And we're going to look at that in part 3, where we look at the actual possession procedure and what a judge has to consider at the different stages. But unless one of those exceptions apply, then yeah, the tenant's going to, their contract's going to end when the landlord gives them notice.
Okay, so I know I'm throwing so many different scenarios at you here, but what if I'm advising a tenant who's actually renting from a private landlord?
Well, same basic tenancies apply. If a tenant's got long-term protection, which is rare but possible, they're going to have an assured tenancy. But most landlords in the private sector wouldn't choose to use those because it's so much easier to evict an assured short tenant if there's a problem. And just what we talked about before with the short tenancies, the same rules apply to private landlords. They can choose just to end it at the end of the fixed term contract and not renew it, get a possession order and the tenant is out. Or within the fixed term, if someone causes a problem, they can issue a notice of seeking possession based on grounds and get a possession order that way. But a key difference is that unless a private landlord is part of an accredited body, then you don't have the right to go to the housing ombudsman. And it's down to negotiation basically with the landlord or whatever the court decides to do if the landlord has failed to comply with their legal obligations. Generally, if I was advising tenants before they rent with someone, I'd advise them to rent through a landlord that's a member of an accredited body, like the Association of Residential Letting Agents, partly because they are going to be familiar with their obligations. They're also bound to follow a code of practice. And if you're not satisfied that the landlord has followed that code of practice, If the accredited body is registered with the Housing Ombudsman, you may have a right to complain to them. However, with private landlords, that's unlikely to stop you being evicted.
So some of our clients are living in hostels, bed and breakfasts, or they're paying rent to friends. What rights do they have?
Unfortunately, very little. If they don't have exclusive possession of the property, they've probably got just a license to occupy, which is still a kind of legal right. And the landlord would have to either give the notice that's under any agreement, or if there's no set notice in anything that's been agreed between the landlord and the occupiers, the landlord would have to give reasonable notice in the circumstances. But the landlord's not going to need any court order to evict them. They could use reasonable force, or just wait until they've left and change the locks on them. Perfectly legal. If the landlord hasn't given reasonable notice, you may have a right to compensation for being evicted earlier than you should have been, but that's not going to get you back into the property. Okay, so just for comparison, this is summarizing the different ways that landlords can evict someone for rent arrears, depending on what type of contract they've got. And you can look at that at your leisure. And again, just to illustrate this in terms of dealing with someone in rent arrears, we've got an example where Bill owes rent arrears since he became unemployed. He owes about 3 months worth of arrears. He's offered to pay it back at what he can afford, but the landlord won't agree. And again, you can read through this at your own pace to see how these situations differ and how the court's powers differ. Time to check your understanding again. So get your pen and paper handy, and I'm going to ask you some questions. You can pause the presentation. In practice, of course, you're going to use useful resources if you're not sure. Have a go, see what you understand, check your answers, and if there's anything that you don't understand, you can always go back over the presentation to check this again before continuing. So firstly, what sort of tenancy am I likely to have if I'm a council tenant and I've got long-term protection? Secondly, what type of tenancy might I have if I rent privately and the tenancy is for a fixed period of 6 months? And finally, what sort of tenancy might I have if I'm a council tenant, but I've only been there 6 months, and the council warned me I can be evicted easily if I cause any problems in the first year? Okay, write your answers, pause it at this point, and when you're ready to go ahead, you can click on forward.
Okay, I'm going to give these ones a go, Matt. I'm ready.
Good. Okay, Rasheen. So what sort of tenancy am I likely to have if I'm a council tenant with long-term protection?
Secure tenancy.
Is the right answer. And what sort of tenancy might I have if I rent privately for a fixed period of 6 months?
Assured short hold.
Is the right answer. Remember, it's got to be for a minimum of 6 months. It can be longer by agreement, but must be for a minimum of 6 months. And finally, what sort of tenancy might I have if I'm a council tenant, just been there 6 months, and the council warned me I can be evicted easily if I cause problems in the first year?
Introductory tenancy.
Correct. And remember, that automatically becomes secure if the council has done nothing to evict you during that probationary period. So, just a couple of last questions. Firstly, what's the standard length of notice to end the tenancy under the Protection from Eviction Act 1977? How much notice does a landlord need to give to end an assured short-hold tenancy under the Housing Act 1988? So pause it here, write down your answers, and then we'll continue.
So question 4, I'd say the answer is 28 days is the standard length, unless there's a statutory rule that says otherwise.
Absolutely correct.
Okay, question 5, easy, it's 2 months.
2 months, okay. Very common. In fact, it's the most common way of ending an assured short-hold tenancy is by giving the standard 2 months notice at the end of the contract. There are specific legal requirements around when that notice should be served and how long it's effective for. But if you see someone who's been given notice by their landlord, then that's something you want to consult a specialist advisor about to check if the notice is still valid. Remember, if in doubt, look it up. Use the useful resources that are in the document that you can download for rent possession guidance.
Hi, it's Roisin again. I'm guessing by now that you're probably ready for a little break. So please just at this point, pause, go grab yourself a cup of tea or a glass of water, no looking at your phone or your emails if you can help it. And yeah, just give yourself a bit of a screen break. And then when you come back, it'll be the final part of the webinar where we're going to be continuing to look at Yasmin's case and just looking in general about advising on potential evictions. So yeah, see you in part 3.